This was a fascinating case because this case presented really several of the ultimate challenges to taking a case to a jury. It was a very minor impact. You couldn't even see the damage really to the plaintiff's vehicle in the photographs, and she had very little treatment during the year following the crash. She then had about a 3-year period where she had basically no treatment. We argued to the jury that she was surviving on home exercise and Vicodin. And then she finally met Serena Hu, the head of spine surgery at University of California, San Francisco, who did a disc replacement surgery on her about 4.5 years after the crash. The challenge in this case really was figuring out how to show the jury the difference between impossible and unlikely. And that really was what the whole focus of this trial was. It's unlikely that you would suffer an intervertebral disc injury in a very minor 3 to 5 mile per hour impact, but not impossible. The solution was to bring in a forensic epidemiologist who was an expert in injuries from car crashes. And in this case, Dr. Freeman relied on the 2 huge look-back studies done in Copenhagen and Japan, where they looked at over 40,000 actual accidents to determine the forces of the impact and the injuries suffered by the occupants. What we found by reviewing these large look-back studies was the really surprisingly high frequency of injury in even low-speed crashes. Dr. Freeman presented to the jury how in even a 5 mile per hour crash, there's a 1 out of 3 chance that the occupants of the vehicles will have some type of injury. In a 10 mile per hour crash, we found that frequency of injury actually went up to 2 out of 3. The most important fact that we were able to show the jury in our case was that statistically there was actually a 1 out of 40 chance of having a disc injury in even a 5 mile per hour crash. So while my client again was unlucky, it was not impossible that she suffered her claimed injury. The plaintiff, Susan Ice Dunnigan, was a very pleasant woman in her early 40s. She had a couple of young children. She'd been through the ringer a bit. This case had been going on for many years. She had had years of back pain followed by several surgeries, and she really, used up the empathy that any of her friends or family may have had for her at one point, and we had to come up with a way to visually show the jury how to compress the 6 years of medical treatment and make it relate to this crash back in August of 2006. The charts that we ended up preparing showed that while my client wasn't actively receiving treatment during the entire 6 years after the crash, when you compared it to the level of treatment that she had had before the crash, her pre-accident and post-accident medical profile were vastly different. State Farm had never offered a dime on this case for almost 6 years, and 5 days before trial I was personally served with a late 998 offer for $22,000. The juror's verdict in this case was a little over $1.4 million, and with prejudgment interest and costs, State Farm ended up paying substantially more than that. This case was a perfect example of the really great part of representing individuals like I do and like many of us do in serious injury and death cases. I was able not only to validate my client's injury that had really changed her life in a significant way, but also finally get her some compensation and some relief for the years of struggling that she had as a result of this crash.